Yeah. Okay, great. So over to you, Ellie. If you can give us maybe an overview, feel free to introduce yourself and your agency as well. I know I've given a brief overview, but please do tell us more about your specific area of expertise, and then we can hone in on the bit about the renters' rights bill.
Yeah, I will try my best as we go through to answer any questions, but this is equally as new to me as everyone else. Although I have spent the last few years of it, as Prithvi said, sort of going through the different stages from the Renters Reform Bill to now being the Renters' Rights Act. I'm also a landlord myself, so although I can't give sort of specific legal advice, I guess a lot of this is sort of my view as not only a letting agent, but a landlord myself. I do completely understand from all the questions sort of we've had over the last 6 to 12 months, really, from different landlords, the concerns in the industry and people sort of wanting to get things right. And I guess a lot of that as well was the unknown because until October, when the government decided to actually put something in writing, it has just been very unknown. And even now, we're still waiting for them to publish some of the things. So one of the most recent changes that we'll start on is the information sheet. So the government have recently published the information sheet, which needs to be served to all existing tenancies by the 31st of May 2026. So it's something that will explain to tenants about all tenancies becoming periodic, about their requirements to have to give 2 months' notice if they wish to vacate. Um, so that has to be given to them by the 31st of May and it can be served via email. Our specific tenancy agreements that we use, we do have something in there that allow documents to be served electronically. Um, there is some talk on some forums that I've seen where there is a solicitor that is also a landlord, and she did say that you could serve it by post if you don't have something in your tenancy agreements that allows for things to be served electronically. However, the government guidance does say it can be served via email. Um, and then with that, I think there's a lot of questions on how you evidence it. You don't have to get the tenants to sign for it. You can just take screenshots as evidence and save that evidence that you have served the email to the tenants. But if you have joint tenancies with more than one tenant, it does have to be served to all tenants. So in the market that sort of we deal in, we've got some up to 8, 9 bed HMOs, and we've got with anyone else that sort of deals with student lets, the properties that are let for the next academic year and the current tenancies for this academic year as well. So that's making sure it's sent to both those groups of tenants. There is also, if anybody is a student landlord and in the future may wish to use ground 4A, which is the new Section 8 ground to be able to reclaim possession of a HMO property. And that is any property 3 plus. So even if you're in an area where a 3 or 4 bed property doesn't need a HMO license, it is still classed as a house of multiple occupation. There are certain points that you need to make sure are covered to be able to use a ground 4A. But at this point, you're not serving the notice itself. You are just letting the tenants know that you have an intention to use that ground. So to all our let-only clients that have got any student properties, we have sent an email out with a template ground 4A, including the information leaflet that has to be sent. If anybody isn't one of our existing clients and wants a copy of that email, I'm sure Prithvi can either pass on my email address or pass your email on to me, and I'm happy to forward on a copy to anyone that wants it. Because that just explains in there how to serve the information You can't send a link to it, for example. You do have to attach it as a PDF. Um, and one other point that gets asked a lot is there is no requirement, as long as you have got a written tenancy agreement already, there is no requirement to reissue the existing tenancy agreement. So the new government leaflet explains all of the changes to the tenants without you having to create a new periodic tenancy agreement.
So Ellie, there are some questions, if I
Mhm.
may, about this itself that have come up on the group. Would it be okay if I brought it up now while it's fresh
Yeah,
in everyone's mind? I
of
think
course.
the question that people wanted to check was, is it sufficient that an agent does it on their behalf, or does it have to be the landlords evidencing the fact that they have shared it with their tenants? I'm presuming when you have nominated an agency to manage the property for you, then the agent sending it should suffice, isn't it?
Yeah, so if you've got a managing agent, they actually have to send it. So even if you as a landlord wanted to send it, they would have to send it anyway. The only thing I could advise is you could ask them for the evidence that it's
Evidence.
been sent. Um, so if any landlords have asked us, we've just sent over to them the screenshots of the evidence that it's been sent. So they've also got a copy. Because it might just be useful for you to have for future reference as well. I guess with the student cycle that we deal with, and they often move out year after year. But if you
Mhm.
maybe have got a residential property and they might have signed somebody up, but they might stay for 5 years, and you in that period you could take over the management and then maybe not have the right evidence that you'd require. So in any of those circumstances, I would probably want to have the evidence for myself as well.
Okay, and the other follow-on question from that is, are we supposed to send this not just to the tenant but also to their guarantor? So sometimes we have a guarantor who's signing as an add-on to mitigate the risk of rent not coming in, isn't it?
There is nowhere mentioned about sending it to guarantors, so it's not expressed or implied, but you could share it with a guarantor for transparency or as good practice, but nowhere on the government's information does it state that. As with any new laws, until there is a case law
Mm.
that sets the sort of precedent, it's always really difficult. So yeah, it may be good practice to send them a copy anyway.
And another question again from the group is, sometimes we have a lead tenant, when it's a group of three or four, just sending it to the lead tenant alone will not suffice, isn't it? We have to make sure that we send it to all of the tenants who are there that are named on the tenancy contract. Is that right?
Yes, it has to be sent to all of the tenants that are named on there.
Okay, great. Okay, yeah, thanks, Ellie. So, yeah, carry on. I might, if questions keep coming up on the chat box, I might keep pausing you and stopping your flow. But yeah, please carry on.
Fine, no problem. Otherwise, it just sounds like I'm talking a lot. So, um, so yeah, I will briefly touch on the ground foray, with the student ones, but I'm aware it might not be applicable to everybody. But I know Quick for you and some of your joint ventures do have quite a few HMOs. So if the tenancy was entered into before the 1st of May 2026, they will be treated as like existing tenancies, even if the start date is in the summer. Um, and there is the 6 month rule will not apply to these tenancies entered into before the 1st of May, but that's just like a one-off transition exception. And ongoing to be able to use that ground, they will have had to be signed up 6 months before the tenancy start date. So it is something we'll go through with all our landlords again in sort of September, October time, which we kind of had these conversations last year because at the time we didn't know when the new rules were coming in. So we'll sort of repeat those conversations again in September and October because it does depend on everyone's sort of risk and how you sort of analyze risk. Because if you've got a 7 bed HMO, you might not want to risk those tenants moving out, but sort of pulling out of the tenancy. So if you're taking a holding deposit in November or December, but saying, we'll keep that holding deposit for X amount of weeks, and sign you up in January, do you then risk the possibility of a group pulling out? Um, so yeah, there's various other complications around that we'll sort of go through again around September, October. And I think you'd had some other questions about like the Section 13 notices as well. Um, and actually, although they have now sort of confirmed in writing about Section 13 notices have always been a thing. You have always only been able to increase rent once a year, but you could previously also agree it informally with a tenant. Um, this isn't something that overly concerns me because we've got a lot of tenants that residentially that we've had in properties for several years. And if we go round and do an inspection and they're keeping the property really nice, they're good tenants, they pay the rent on time, we will generally have that discussion with the landlord. Um, and yes, the rent might have gone up a very small percentage in that time, but for the sake of £25 a month, do you want to risk losing some really good tenants? And we do deal with quite a small area. So we're based in Sheffield and we mainly cover the S10 area. And so I appreciate people based sort of all over the country. The areas might be different. And if you're in London, I imagine the rents sort of increase at a faster sort of percentage as well.
Ellie, I
Um,
think it's worth clarifying for the group what Section 13 actually is. I know for
okay, yeah.
you it's day-to-day bread and butter. It might be useful for the group to just clarify what Section 13 is.
So basically to be able to increase rents um ongoing after the 1st of May, you will have to use a Section 13. Although the government like to confuse you, and their new form that they're creating will also be called a Form 4A, which is different to the ground 4A and the written statement for the students. Um, this is not live on their website yet, the new form. There is one that you can view in advance, but they won't make the actual Form 4A live until the 1st of May. Um, Tenants will be able to challenge rent increases through the tribunal. Um, Again, looking at this on maybe I'm just a positive person, I don't know. But if you've already got tenants that you've got a good relationship with, you've spoken to them in advance before serving the official notice. Um, I feel like a lot of this could be managed. I think the main things for me with all the new rules is that certainly for us and how we handle and deal with things, it's going to be a lot more admin, making sure things are done properly and trying to keep everybody happy. But ultimately, I think having that good relationship with the tenants would avoid tribunals. And I do think to all of a sudden one year to decide to hike a rent up by £300 would be unfair. So I would side with a tenant on that, if you're only increasing a rent by a small percentage, I can't really see a reason why they would want to dispute that.
I think it's
Um,
important here to highlight, isn't it, Ellie, that in reality, most landlord-tenant relationships are generally healthy if both parties are keeping up their side of the contract. So if a tenant is paying their rents on time and the landlord is making sure that it is safe, habitable accommodation and is being responsive and maybe even has more of maybe a personal connect with the tenant, usually things should go hunky-dory, exactly like you said. You go to the tenant and you say, listen, I'm prepared to do something for the property, but I'd like to increase the rent in line with the market rate. And maybe you show them evidence of or the neighboring property has been let out for 2 or 3 months back, and it's unlikely they will dispute it. If it's a very clever tenant who knows how to hack the system, they could dispute it by saying, I'm going to take it to the tribunal. Nobody has got that kind of time, but let's say they take it to the tribunal. I believe till the time that the tribunal resolves it, they still have to continue paying the previous rent, or can they be exempt completely from paying any rent till the tribunal resolves it? Would you know?
I think you just can't. So historically, they'd pay the higher rent until the tribunal, and now it'd just be the
Other way around.
previous rent, basically. Yeah.
Yeah. And I think that's one of the questions I think that's come from the floor as well. Would it be okay to informally first agree with the tenant if you have that kind of a relationship, and then to issue the Section 13 to formalize it? Or is it illegal to first to do it in that order is the question.
You could discuss it with them, but they would still need to have those like 2 months notice or before. So it used to be 1 month's notice before the proposed rent increased, and it's now going to be 2 months. So you could first discuss it with them and then give them the 2 months notice in the official format. Um, that would personally, I think, be the approach I'd rather take rather than just serving someone a legal notice. I feel like having a discussion with them first and explaining it, and then following up with that. Um, we've had some tenants at the moment while we've still been able to serve Section 21s until the 1st of May. And we've got some fixed term tenancies that are sort of coming to an end, and we're wanting to know if we're reletting those properties. And so, for example, we asked a tenant in a two bed that will fall outside the scope of the ground 4A rules with the student market. And they said they will be moving on. So we've gone ahead and sort of replied to them saying, we will serve a Section 21 notice just to confirm the end of the tenancy, because then that's just an extra security for us. But again, we just explain that in advance because otherwise they get a legal looking notice, and we have had replies before, um, and it just confuses people.
Yeah. Okay, good. So what you're saying is once a year you're allowed to negotiate on the rent increase. You can't go berserk. You kind of got to keep it at market rate. I think it's actually good practice to keep it in line with whatever is there as a market rate. We've been in situations before where people have kept an old tenant on for 5 or 6 years, and then suddenly 5, 6 years later, if you tell them the current market rent is X, and that's 30, 40% more than what it was 5 years back, that can be a bit of a shock, isn't it? And even for them to relocate and move to a different property, the market rate is the market rate, and so that can come up as a shock. So it's a good idea to keep doing, but also keep providing some kind of value add to the tenant as well. That's a good suggestion, Ellie. One of the questions is the renewal of current tenancy is effective from 3rd of May onwards. And my understanding is that we can still request advance rent now, um, as the new regulations won't come into effect until 1st of May. Advance rent up until 1st of May. We're already in April, so you should be collecting 1 month in advance anyway. But after the Renters' Rights Act comes in, you're not really allowed to take advance. Are you, Ellie?
Um, so we, if a tenancy agreement was signed and fully sealed before the new rules, um, so basically for a lot of our student properties, we have still put quarterly rents in, but they were all signed back in November, December with a start date for the summer. So because they are existing agreements, um, as far as I'm aware, and I have taken some legal advice just to double check, but they believe the interpretation of existing agreements is that it's signed prior to the rules coming in. If we had anyone, we're quite amenable to people coming to us saying, can I pay in line with my loan? Can I pay monthly over the summer and things anyway? So if it was a problem for anyone, we would look at working something out anyway. My concern with this question, if someone failed credit referencing, um, is that that period of rent in advance might solve you a very small problem, but when that agreement ends, you're going to be stuck with those tenants. It sounds a bit like, though, it's a bit late to do anything about it. So even as you can serve Section 21s up to the 1st of May, but yeah, you'd need to speak to a legal professional, I think, in the next couple of weeks if you decided to get somebody out so close to the rule changes. Um,
So, yeah, just to clarify my question, so yeah, it was me who posted the question there. So they are my current tenants, and yeah, so the 12-month tenants agreement will finish on the 2nd of May. Uh, so the reason the credit reference failed is because they don't have the history in UK. So yeah, I mean, even though they're living since 1 year, they don't have any utility bills, or they don't have any UK bank accounts because they are still working for the same company abroad from here. So that's why the credit reference failed. So when I say advance rent, so I'm not just talking about 1 month advance rent. So I'm talking about like 3 or 6 months advance rent, that kind of thing. But my understanding is, so the existing rules will still apply, because the new rules won't come into place until 1st of May. So I
that,
just wanted to double check my understanding.
yeah, so um even if it was, so you couldn't put it in the agreement after the 1st of May, for example, that somebody could pay quarterly. But if, say, a student came to us and said, can I pay a quarter in line with my loan? You can accept it. So potentially, if you've already got a good relationship with those tenants, they're happy to pay you rent in advance before the rules come in. Um, it's yeah, it's just with it being around that date, you need to be careful of the date the agreement was signed. So
Yeah,
if you are going to take 6 months in advance, you need to make sure that agreement is signed and finalized before the end of this month, because on the 3rd of May, no, that will be illegal.
yeah, yeah. Understand. Okay. Yeah, I mean, just to one more clarification, this is not a HMO property. This is just normal,
Mhm.
normal tenancy.
Yeah. It is the same with the
Yeah,
rent in advance for all properties. But I think my concern with that would be, you know them if they've been in there for 12 months, so it's on your
yeah,
relationship and what their income is and everything like that. But I think quite a lot of the problem with this, which goes on to my next topic as well about effective tenant selection, is the thing that the government haven't thought about. We've historically had a lot of people coming over, and some might be resident doctors that are coming over for training, people that have in the past been really good tenants that don't have, maybe fixed term contracts or any credit history or anything, or maybe some people that come over and don't have proper jobs confirmed yet that would have paid 12 months in advance. And I think the government have really failed to recognize what problems this will cause for people, because we just won't accept those people anymore because of the risk. If they can't meet affordability, you are within your right to decline people if they don't meet affordability to pass referencing. So I appreciate in this instance they are existing tenants. So they might be keeping the property in a good condition for you and you might be happy with them. But in future, I would take the view of how many other applicants have I got? Again, I'm based in an area where often we have a choice of tenants. And I also think that meeting people and getting a vibe from them on a viewing is sometimes more or as important than referencing an income because you can often get a good idea of what somebody would be like as tenants from a viewing and from meeting them.
Yeah,
Yeah,
thanks,
I
Ellie.
mean, yeah,
Santosh, can I suggest that Ellie carry on with certain other aspects of the Renters
sure.
Rights Act? We'll come back to maybe your questions again towards the end because there's still lots of areas that need covering, and I'm just conscious of the time as well.
And I think one of the other things that you'd asked about as well was like the sale of a property. So there will be a ground 1A, which does under Section 8 notices, which will still be able to use. Um, I think it is quite an unfair ground. Um, because basically, if, for example, you were selling a property, you can give 4 months' notice to a tenant as long as they've been in there 12 months. So you could give notice at month 8 for them to move out at month 12. However, if you put the property on the market and it doesn't sell or a sale falls through, you will have to wait 12 months to be able to relet the property. And this may, um, so I do actually have a sister company as well that does investor sales. And I guess what this rule might mean for a lot of landlords is that you might be better off selling with a tenant in situ and selling to another investor, um, because it does sort of help mitigate the risk of voids really. And that could be a big void if you don't sell that property or a sale falls through. And I think the stats are something like 1 in 3 sales on a general market fall through. And so then there's a big risk there. If anything happens with that sale, you then have to wait such a long period to be able to relet the property. Um, and the Conservatives under the previous bill tried to reduce that to 6 months, which was a lot fairer. Um,
So Ellie, when you answer each one of those questions have been pooled together from different people in the network, so they may not know which question you're
okay,
addressing. I think you were trying to address the question of if a landlord wants to exit the property and wants to sell the property, what does he need to do? He needs to give a 4 month, as per the new act, he has to give 4 months notice for a tenant who's been in the property for at least 12 months. And if after 4 months he cannot sell the property, then he's stuffed for almost a year because he's not allowed to relet. So what you're proposing as an alternative is either take it to auction or sell it to another investor, landlord, but with the tenant in situ. So you're selling the property with the tenancy within it, isn't it? That's what you're saying. Have I understood it
yeah,
correctly?
yeah. I might be slightly biased, but that's
Yeah. Okay. Yeah. No, got it. Okay. That's good. So if you can first pose the question, because the question has come from different members of the network.
and then I think I've got your questions here as well. I think somebody asked about the landlord database or the private rented sector database. Um, that is one of the things that hasn't come into force yet. And so I think there's so much coming over the next few years that the main things to focus on would be the things that are imminent now.
Mm. Yeah.
So when it launches, it will be compulsory for every landlord and every rental property to have an active entry on the database. But when the government implemented the roadmap of the new rules that was published in November last year, they referred to the database starting to roll out from late 2026. And they've also got so much still to do for the upcoming things in May. I wonder when in late 26 they'll let us know. But then it won't become mandatory until 2027. So yes, there is something coming we don't really know a lot about it yet. There's going to be a cost that I think might be per property, but I think that's one that we'll wait for more information on and not something that you have to do right this second.
Okay, that's good to know. So we can kick the can further down the road and just
Yeah.
react to it if we need to. Okay.
And then I think the other one that somebody asked about that's a very similar one, hopefully I pronounce his name correctly, but the Awab's Law. So that it was something that's coming for the social housing. So I think a lot of people have heard about it as a new rule, but again, it's not come in yet for the private housing or the private rented sector. Um, we actually manage quite a few properties that are next door to social housing. And I can assure you that none of the houses I have ever been in are in such bad disrepair as those houses. So I feel like bringing that in for the social housing sector was a necessary step. Um, and also just another thing to point out that damp and mold is already covered under like the health and safety rating system, and local authorities can already take action if properties aren't safe. The new law will just formalise things a bit further, and particularly around like response times. Um, but I think if anyone ever comes to us with damp and mold, as an agency, we're already really quick to deal with it and get it investigated. Um, even if that is us going round, if we think it's condensation mold. I actually studied construction, the built environment, and I actually love damp mold and assessing what the what the problem is. Um, so yeah, and likewise, our maintenance manager in the office is also really good at assessing those things. Um, so sometimes we can go around do an inspection and be able to sort of clarify what the cause of that is.
But the take-home
Um,
message, Ellie, the take-home message basically is that if a tenant reports damp or mold, it requires a certain level of quick responsiveness either on part of the landlord or their nominated agent to go there
yeah,
and at least respond to it quickly and then think of a plan after that in terms of how to remedy it, isn't it? We need to be shown to be responsive as
yeah.
well.
And if it does take some investigating and needs further investigation, we use a spray HG mold spray, which will treat the area, which might not resolve underlying issues, but it gets rid of that initial mold spore hazard whilst it's being investigated.
Yeah.
So that's one thing. It's a really good spray. I dread to think it's in it, but it does the
That's a
job.
good that's a good tip for everyone. So time buying measure while we find out the root cause of what's going on. Okay, brilliant.
Then I think somebody else asked about the landlord ombudsman. Um, so again, this was in the roadmap that was published in November 2025. They don't that won't be a requirement for landlords to become members of, I think, until 2028. The name of the spray is HG mold spray. I can try and
No, no,
see
don't
the
worry. HG
is that
mold at £5 on Amazon. They'll Google it and they'll find it. HG mold spray.
I'll pop it. There we go. I use it myself, so but it's great for you to keep your shower sealant white.
Great stuff.
So yes, there will be a landlord ombudsman. We so as an agent, we've had ombudsman for years that we've had to be members of. I suspect it will be the similar sort of thing. Again, we don't know what the fees will be for that. But it's not something to worry about just yet because that's a couple of years away as well. Um, so yeah, that was that one. Um, Just trying to check what other questions you had. I'm trying to think if I've seen it. I've seen it in hardware shops, HG mold spray. Our local hardware shops both sell them, in Broomhill and Crooks.
So
But if you're not local,
there was a question, Ellie, about bidding, rental bidding. Because rental bidding is now not permitted under the new act. So how would you, particularly when you're only allowed to increase it after a year, and maybe if you've had a good tenant for 2 years where you've not increased the rent, 2 years later, you've got a sought after product, lots of people want to view it. Do you start high and then hope that people offer something below that? How do you work your way around the bidding? You obviously can't get people to bid, but are there any strategies that you would suggest or think of for landlords?
yeah. So as an agency, we achieve some of the best rents in the area anyway. And so I think our approach has, regardless, always been you start high. I think rental biddings may be more common in London where you get so many people
Mm.
desperate for properties, whereas it's quite rare that it's a thing for us here anyway. Um, so yeah, I think that will be exactly it. For the right tenant, you might be able to reduce the rent for somebody, but yes, because you can't accept any higher, you're better off putting the rent on at a slightly higher price. So I spoke to a landlord today that has just been given sort of 2 months notice from a tenant, not 2 months because the new rules, just his tenancy was ending at the end of June anyway. And again, because he's got, that 2 month period, he's like, well, we'll try it for a bit higher. And, in a few weeks, if we've not got the interest. So for anyone that advertises on Rightmove, sort of dropping the rent by 2% gives it a boost back up the listing. If you're on a Rightmove mailing list as well, it then gets back emailed out. It does then say it's been reduced, so some people don't like that idea. So I think pricing it right is quite
Right. Yeah.
important, but the slightly higher end of right um would be the price I would go for, because yes, you obviously can't accept any higher, but you could negotiate slightly for the right person.
Okay. I'm asking questions for people who have messaged me directly here. Um, so the other question that some people have is that if we are operating in a market where we have, for example, a group of 5 or 6 students, what happens if one or two of those choose to give their notice and leave, and you still have 4 others who are carrying on with the tendency? What happens in that situation?
Does that say, sorry, if it was a joint tenancy or
Yeah, if it's a joint tenancy.
yeah. So under a joint tenancy, one tenant can give notice for the whole house. However, unless they have fallen out, which does occasionally happen,
Hmm.
um, so what's quite common is getting students that drop out of university. Historically, we have always said you need to find a replacement tenant. This is what we will continue with, but the difficulty now is that legally one tenant can give notice for the whole house. Um, we've had it before, where we had one tenant that wanted to leave. Prithvi, you might remember this one, but where the parents were horrible, and we actually
Hmm.
said, we can relet it, we'll surrender the tenancy. And the other three tenants said, no, we really like the house, we want to stay. And so that I keep using as an example to everybody, because when I'm asked that question, that just shows we even tried to surrender that tenancy to just relet it to a new group. But the other remaining tenants wanted to find a replacement tenant so they could still stay on in that house. In which case, dependent on the time of year, um, we've got some at the moment. So before the 1st of May, we're just reissuing new tenancy agreements with the replacement tenants. After that, we'll probably just continue with deed of assignments. If you really did have a problem in a house. We've got one girl this year that has fallen out with all of her housemates, and I think under new under the new rules, she could have been one of these people that gave notice for the full house. You could then suggest to the group, you stay on, whether you let them stay as five and whether they're willing to pay a little bit more rent or whether they'll let you find a replacement. So I think it's going to cause a lot more work because historically we've always put it back onto the group of
Mm.
tenants saying you need to find a replacement tenant. But now if we say that, they might say, oh well, we'll all leave or we'll give notice anyway, or it's just going to be a lot more work basically.
Okay. And
Um,
for vanilla tenancies, standard let out to, let's say, a family, etc. If we if we think that some of these families are almost going to use it like an Airbnb, where they move in and give you your 2 months notice or 4 months notice because of change of circumstances, I can see from a landlord's perspective, everyone moving every 4 months means three changeover tenancies in a year. As a letting agency, how are you going to recalibrate your fees, etc., for this? Because every time there are marketing costs, there's a tenant finding fee, etc., that a landlord would have to bear, isn't it? Are there any thoughts on this kind of a situation across the agency landscape, or is it just it's a cost the landlord's got to bear the brunt of it?
yes, I mean for us it's the same amount of work and we're putting a lot of work and have done over the years for all these changes. But my point on that would be when you reference somebody, you should know how long they've been in their previous accommodation. You whilst it's not a fixed term, you can still gauge an idea from somebody what their job is, how long they're
Hmm.
looking, and you might get a young couple that move into a one bed flat and split up after 6 months, or circumstances can change, but there are also a lot of things that you can do to try and mitigate that. So it goes back to the whole tenant selection thing. And I think as an agency, we care quite a lot. Um, and I guess at this point for different landlords, it's sort of reviewing who your agency is and how much they do care, because I think there are a lot of agents that don't. If we had several applicants, we'd be going to landlords with the different applicants and what we thought to them and how long we thought they might stay. Um, so even at this point, we've got a residential property up for let at the moment, and we've just shown them there's a resident doctor that's got a 2-year contract at the Northern General. And so, they're hopefully quite a solid applicant that
Yeah.
you'd hope there's no guarantee they'll stay for 2 years, but it's looking at the paperwork and what contracts they've got, and thinking, all right, yeah, they might stay. And I think one of the most important things for me that I've been trying to pass on to landlords, the quality of your property and how well the tenants are looked after are two of the most important things, because why would they want to leave if they're happy in a home unless their other circumstances change that are out of everyone's
Yeah.
control? But why would they want to move on? And we've had so many residential properties that have moved in and stayed for years because they're so happy. And I guess it comes down to as well the things like one bed flats have a high turnover of tenants because people grow and they move on. And so if you're looking at portfolios and what you're looking to buy, sort of considering what is more acceptable as a longer term home to people. We have a one bed flat above our office, and years ago, the first tenants in there absolutely loved it. Lovely tenants, were always so nice, like brought us present when they moved out. But the only reason they left was because they wanted a 2 bed so the friends and family could come and stay and visit. And I think that's quite common in that size property.
So front loading a lot of the tenant kind of screening right at the outset um, is something that we as landlords either need to do ourselves, or when we nominate an agent, we need to get them to do that. I know you're different, Ellie, because you actually go for the viewings yourself to get a sense of what the tenant is like. A lot of these national agencies, they send people to go there with a checklist, and everyone sits on a computer and tries to do these reference checks. And if everyone's ticked all the boxes, then that's an okay. And in reality, we know that you could pass all these little checks, but you could get the most problematic tenants in spite of all of that, isn't it? That is the reality of it. Um, okay, I'm conscious of time. We have only 10 minutes left. So I'll start taking questions if it's okay with you, Ellie, unless there's
Yeah.
anything else that's burning from your perspective about the Renters' Rights Act that you want to tell us about. Um, there's a question from, let me go through it in order. Bevan, you said you have a question before we finished. Go for your question, please. I'll go in order.
Okay. I saw something on the news a couple of weeks ago where they said a landlord owning up to 3 properties would be seen as a small entity, and it would be easier to remove tenants under certain circumstances, one being family moving in or that you're selling the property. Any landlord owning 4 properties or more would be treated like a bigger organization, and then removing tenants would be harder. Have you come across this yet by any chance?
So if you are using a discretionary ground under the Section 8, that any of those are down to the discretion of the court. So I would assume that they were referring to how the court would view it. So I guess if you're a bigger portfolio landlord using a non-mandatory ground, they might look at those circumstances. Um, I haven't seen the exact thing that you mention.
Okay.
So there is a ground for if you want to move back into the property. There
Mhm.
is the ground 1A is a mandatory ground. So the one of the sale of the dwelling is the one that we talked about earlier. So um the main point with that is that you just can't relet the property if anything happens with the sale.
Mhm.
As far as I'm aware, so provided the landlord can convince the court of a genuine intention to sell, they'll be able to sell with vacant possession using a ground 1A. As it's a mandatory ground, the court will not need to consider whether it's reasonable to evict the tenant. The
So can
act
I
doesn't
can
specify.
can I can I just stop that up, Ellie? So just to give it some context, I think I know what Bevan's referring to. If you're a non-portfolio landlord and you're reliant on your 3 properties for income, and you're under demonstrable financial duress, then you can write or appeal to the courts to take a view and not necessarily have the 4-month rule applied to you, because your financial circumstances require you to, let's say, sell the property. If you own 4 or more, the courts are going to question how is that one property going to really make a huge change for you. You should be thinking about this in advance. So it is purely from that lens. I don't think there is any case law or anything as yet, Bevan, because this has not been explored. So this is all discussions, if you like, as it stands at this stage.
No, mate. Thanks for that. I was the reason behind it is then, do you, if you're looking to build a portfolio, do it under a limited company for 3 properties, then do a new limited property for 3 properties to keep that kind of excuse to get out of it. Because
Mm.
what I saw was that it will be
So
a lot harder.
I can answer that straight away,
Okay.
Bevan. Even if you own 3 in one entity and
Hmm.
then 3 in another entity, they will know by going to company's house that you have an interest in 6 properties.
Okay.
So even when a lender or anyone, even the courts look at it, they will look at how many do you own as assets in total, or where
Okay.
where where do you have a right in those number of properties.
Okay.
So
Thank you.
don't let the tail wag the dog. If you want to build a
Yeah.
portfolio, you build the portfolio. Don't let this
No,
go
I was
your
just
way.
checking because when they said, 3 properties is seen as a small entity, if you just had, say, 10 small entities, if they dealt with as individuals rather than one big one. That was
No,
my thinking.
yeah, no, good thoughts. I can see how you're looking at it from a lateral angle, but unfortunately, no, it's all going to
Okay.
be very, very transparent from here on.
Okay.
Next question. Sorry, Bevin, that was the one question, isn't it?
Yeah, that was the one question. Thank you.
Yogesh's question, is there a way to mandate a tenant to leave by a certain date if mutually agreed? I don't know what you mean by mutually agreed. The tenancy contract is going to be standard. He asks then, can I sign a deed of surrender in advance?
What I mean, sorry, I'll come in. So I got tenants. They want to leave mid-October. I want to leave mid-October. We're all happy, verbally agreed. And then obviously I want to book some builders in or someone on the day after they leave. So some way that they have to leave, or there's penalties on the middle of October, like pre-agreed, or can they just change their mind and tough? Because the deed of
They
surrender
could,
works on the day, but I don't know if you can post date a deed of surrender, if that makes sense. Yeah.
so you can mutually agree a date. So if, for example, if it was somebody, instead of giving 2 months' notice, you agreed that they could give 1 month's notice, I know you can mutually agree something different, but because that's so far in advance, they could give you their 2 months' notice in writing early, so after the 1st of May, but tenants are able to retract notice. If, however, they're the ones that have brought it up, we had one recently that came to give their month's notice, but they were buying a house. And last time I'd done an inspection, we knew they were looking, but they weren't very far on in the sale. And I said, are you sure you want to give a month's notice? Because how, is this going to complete in time? And they then retracted the notice and said, oh no, we've realised we're not far enough through the sale. So I guess I would again, what is their reason for leaving? What is the likelihood of the leaving then? And I guess a lot of me in business and with our tenants is that we do rely on trust. The student cycle sort of quite commonly moves on naturally. So if you know their reason for leaving in mid-October, why would they change their mind? And yes, there will be a percentage of cases that might. So I appreciate the question, you wanting something in writing to book the builders in. But if you know them and what their position is and where they're moving to, that'd be sort of how I'd take a view on it.
Well, I just don't want a situation of paid builders, I know, 20 grand deposit, and then they can't do the work. So is there a way to contractually, a deed of surrender, I believe, only works on the day, you can't say deed of surrender but dated or October. Have you ever done that? Or, don't know.
Under the new rules, obviously we've not ended any contracts
Yeah.
at this point because they don't come in until the 1st of May. So I think even on some of the like legal forums, a lot of advice would be to take independent sort of legal advice on something that's sort of a bit different or not being come across yet. Um,
I would suggest here that because it's so niche and so specific and there's a legal element to it, maybe speaking to NRLA, if you are a member, with them about this specific instance may be useful,
But
Yogesh.
isn't this a common scenario? Tenants say, yeah, we're verbally leaving. I've emailed you on this day, and they don't actually leave on that day. That must happen, or does that never happen to you? Oh, but they leave 2 days later or something. Is that rare? Yeah.
Very rare. I mean, I can't think of any
Okay.
situation that has happened to me like that. Normally,
Okay.
constant channels of communication are open, and when they give their notice, it is they driving the process and saying they need to exit on a given date. So they would have given you plenty of time because they need to work out their belongings, etc., to be moved out for cleaners to come in. So they understand all of that. Never happened so far to me. But I appreciate you're operating in a slightly dynamic and different market in London, Yogesh. Uh,
Yeah.
Next question about this is, I think, again going to rent increase and being challenged in tribunals. Deepak, if you're around, you can ask the question yourself.
Hi. Sorry, I'm in a car, so you might not hear it correctly. Um, uh, Thank you for the wonderful webinar. So my question essentially was, I have a block of apartments, and the rents vary between 700 to 900. So the newer ones who joined last month might be paying 900. The other one who's been there for a few years pays 700. Now, after 1st of May, when I do give notices, say, let's say, for example, the £900 one, both of them, we increase a small amount of rent. 25, 30 pounds per month, a very small percentage increase. But if the 900 guy goes to the tribunal, and then would the tribunal have the powers? I believe they do, that they can reduce the rent as well, whatever rent they are currently paying. So is there any chance that they can actually look at the other rents and say, oh, the other guys play less, so we're going to reduce your rent from 900, let's say, down to 850 or something? I know, I appreciate it's not come into vogue, but as a letting agent, I was hoping to get some ideas if there's been any chatter on that, because you might have in HMOs as well, you might have people with different rents. But when you do the rent increases, would the tribunal have the powers to ask you for rent comparison for other people in the block and stuff, and then maybe reduce the actual higher rents? Because that can create a huge problem with lenders and stuff, because they would have a stress test against the current rent and given you a mortgage of certain amount. And if the tribunal, who I believe has now the powers to reduce rents as well, not just increase.
So in the details in that, it just says about this means they will have 2 months to challenge the increase. So I think a lot of the changes mentioned, I'm pretty sure under even the current rules, there is a period of time for them to challenge it. But with the market we deal with, we often increase the rents as the tenants leave and on renewals every year with the sort of student HMOs. So we've not served a Section 13 notice recently, and I've never had any rent disputes or anyone querying sort of rent increases either.
So
Um,
if I may just jump in there as well, Ellie. So Deepak, if you've had a lender send a valuer across and they have estimated what the market rental value to be, that is a form of evidence for you. When you go to a tribunal, basically two parties have to put forward their evidence. The tenant will put forward the evidence and say, my neighbor is only paying £700, and then it is the onus is on you to demonstrate that the flat that you have let out at £900 is better than the one that is there at £700, or similar comparables within a quarter-mile radius per square foot for the spec that is there. Now, in the worst case scenario, you are right. The tribunal may say, on the basis of evidence, there is no other block, there is only Dr. Deepak's block which has all these flats, and like for like, there is one which is only charging £700, and so that is the market rate. If that is the market rate, then yes, they do have the right to drive the price down to what the tenant has asked for. So if the tenant has said from 900 he wants it being brought down to 800, then 800 will be honored. It's not that they will bring it right down to 700. It depends a bit on what the tenant is demanding, because the right is with the tenant to demand what he thinks is fair market rent. I hope that answers the question.
Yeah, no, that's fine. Thank you. It's only because the 700 rents are legacy tenants from donkey's years, and the new market rents are all around 900. But yeah,
But it is market rent that will be used as the benchmark, not legacy rent. So if there is one apartment in that block of 10 and the remaining 8 are let out at 900, the tenant can't use the £700. What you choose to do with tenant A is completely different with
yeah,
what you may do with 7 other tenants, isn't
fair,
it? So
fair.
you'll be fine.
Yeah, sure. No, is there a market, is there a software where you can evidence all these current market trends for the court for the future? Do
so we use in our Rightmove membership, we have access to the back end of Rightmove.
Okay.
So we can see sort of historic anything that was listed on there. So you could go back to 2002 in this postcode within a quarter of a mile radius for a one bed flat and look at all the rents and details, and we can see like the old listings, the old photos, the old descriptions. So we can also, if we're going out to value a property, we can create a best price guide. They do now do an electronic one as well. That means that the landlord can see some more of the older photos and things as well.
Right.
And I think sort of estate agents, when they're going out to value a property, will use something
No,
similar for the
that
same.
answers my question. No, thank you. I think for you as letting agents, I think you have the premier Rightmove membership, but for self-managing landlords, I wasn't aware of any, so that was the reason for the question.
But there are some third-party surveying firms which are already being asked to register with these tribunals, Deepak. So
Okay.
in the event where there is a dispute, the court will order for one of these surveying companies to
Oh, okay.
go and determine what the true market rent is.
Okay.
So
That's fantastic. Thank
there
you.
will be recourse to that.
Yeah. Thank you.
Next, quick two questions. We're running over time already. If the tenant has a guarantor, does the guarantor position change and the tenant now has a new get out of jail pass?
It does depend on your current tenancy agreement and guarantor agreement, but no, it shouldn't change anything. The guarantor should still be a guarantor for the length of that tenancy.
Great. So Sanjay has put in a comment saying, thanks guys for a very helpful webinar. So well done, you and me. I'm going to pat myself and I'm going to pat you on the back. If there are no more questions, then I think dinner is calling. I think I would like to summarize by saying that, for people who are good landlords and who will establish a good relationship with their tenants, I don't think there's anything to be worried about really. Most tenancies will go smoothly. Most tenants will pay their rent on time. If you're a risk averse person and you've done all the due diligence and the rent checks, sorry, the referencing appropriately, there are ways by which you can mitigate it by doing rent protection guarantee, using a guarantor, etc. So all of that actually is not going to change. So there's a lot of noise at the moment, but I'm not worried. I'm not worried for most of us here. We're professional landlords. As long as we continue to work professionally and we actually use services of professionals like Ellie who know what they're doing, niche boutique kind of agents, I would say, are far better than chains. So do think about that before employing the services of an agent. Unfortunately, you all can't relocate to Sheffield, and I'm keeping Ellie here. So you're going to have to find your own Ellie. So, Ellie, thank you so much for giving us your time and your insights this evening. This has been quite informative, certainly for me. Thank you for your time, and thank you everyone for joining in. And I wish you all a good night. Thanks.
Thank you.
Thank you.
Thank you.